We are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you so much. Welcome to this morning's sitting of the Appeals Court. We are, of course, sitting by video conference in light of the coronavirus pandemic, and we will fight our way through what technical difficulties we have. The rules are as they are in the courtroom, which is 15 minutes per side. There is no rebuttal. The counsel are reminded that these proceedings are being live streamed on YouTube and archived by video recording. Your cameras and microphones may be on at any time, so you should just be aware of that as we proceed. We are grateful to court staff for their very hard work in organizing these video conferences so that we are able, to the best of our ability, given the circumstances, to provide the parties with the hearings and process to which they are entitled in light of the serious interests that are at stake. We will be hearing 4 cases this morning. The first one is number 19-1162. Oh, I should have introduced my colleagues. I'm Justice Rubin. My colleagues this morning on the bench are Justice Milkey and Justice Massing. The first case is number 19-1162, Commonwealth v. Arias, and we will hear first from Mr. St. Lawrence.
Good morning, Your Honors, and may it please the court. Tim St. Lawrence for Angel Arias. This is an appeal from the denial of a motion to suppress and a motion to reconsider that denial. We submit that the judge erred in denying the motion because the police acted unreasonably at 3 different points during their encounter with Mr. Arias. For the purposes of argument, I'd like to focus on the second 2 points that we raised in the brief. And so to begin, the first that I'd like to talk about is the police smashing the driver's side front window of Mr. Arias's car, forcibly removing him from the car and placing him in handcuffs. And we would suggest that this use of force was tantamount to an arrest, which required probable cause, and that the police at that point did not have probable cause to believe that Mr. Arias was in possession of drugs with the intent to distribute.
Can I stop you there and ask you, so because we're not, since you skipped the first point, so for the sake of argument, we're assuming at this point the police had reasonable suspicion, and that reasonable suspicion would justify ordering him out of the car, right?
Right. Assuming for the sake of argument that there was reasonable suspicion and therefore the officers were reasonable to approach the car and order him out. It was not reasonable though to do what they did because they only had it at the very most. All that they had was reasonable suspicion, and so to use that type of force is not proportionate to reasonable suspicion.
What were their alternatives at that point? If they had the right to order him out of the car and he's not coming and he's doing something in the front seat, what could they have done? Right.
So our argument is they shouldn't have even done, ordered him out of the car, but assuming they had that authority. And this is where I think the Commonwealth's proof at the hearing fails, because they had the burden of proof to show this was reasonable. The police, or there's findings that he did not immediately comply with the exit order, but we just don't have any other specific articulable facts about what that means. Did he not comply for a couple seconds? Was it 30 seconds, which may be reasonable then if he's not going to comply? You know, his windows are closed. This is not a situation where he's pulled over and so he's preparing because he sees overhead lights behind him. He's parked in a residential neighborhood and these officers approach out of nowhere, I would suggest, on a dark night. And his windows are closed. It's February. He may have music playing in the car. So I don't think that without more articulable information from the police that, you know, should have been brought out at the hearing, what this non-compliance really meant. Was it?
Well, he didn't get out of the car, right? I mean, that's clear. I don't know how long he didn't get out of the car, but he didn't get out of the car. If he doesn't get out of the car in response to an exit order, a lawful exit order, I mean, obviously I agree with you. He has to be given a chance to get out of the car, and we have to, you know, he has to know he's being ordered out of the car and so on, you know, but let's say we have a person, there's reasonable suspicion. The case law indicates that you're allowed to order that person out of the car in order to do the Terry type inquiry. If a person doesn't get out of the car, and let's leave aside furtive movements and fear of danger and so on, what are the police allowed to do in order to effectuate the exit of a person from the car? Well, what's your answer to that?
Right. So kind of divorcing from what we know here, because we don't know a lot about whether he recognized the exit order before the smashing of the window, how long or what the police did to make sure that he knew that they were ordering him out of the car. But taking your hypothetical that the Commonwealth adduces evidence at the hearing that the police officers took steps, reasonable steps, to make sure that the person was on the same page with understanding the exit order, then at that point, I think they have a couple options short of smashing the window. In this situation, there were 6 officers, multiple cruisers, I would imagine. So you can box in the car, and then you can figure out different ways of getting into the car if he's not going to comply. One safer way would, if you're going to need to smash out a window, I would suggest you could get a locksmith. But if you were going to smash out a window, don't do it on the driver's side front window where the man is sitting. Do it on the passenger back window and enter the car that way. Certainly there were 6 officers here that could control the situation without taking what I would suggest is a pretty drastic measure, a pretty extreme measure of.
Did they draw their guns in this case?
I don't think there was any evidence that they drew their guns. I would have to double check on that. They certainly, you know, had weapons, but I don't believe they drew their weapons.
And you say there's evidence that they smashed the front driver's side window?
Yes, that's what the motion judge found in his findings. So for those reasons, you know, it is the Commonwealth's burden to show that this was reasonable, and I think they had to develop these kind of non-compliance facts that they point to. You know, there's also a suggestion that he begins to move, but obviously being startled in this situation, I would suggest. And number one, you may move. Number two, if you're trying to comply at some point, you're going to need to move. And the thing about the movements is they're not furtive movements. We don't know anything about the movements. Again, it's just not developed enough. If the movement is a hand to the mouth, obviously, then that's a movement that would justify smashing the window in that circumstance, I would suggest, because then you have direct and articulable specific facts that he is concealing evidence or he's going to try to destroy evidence that way. But you don't have that in this case. So I think the Commonwealth, you know, failed to meet its burden based on these facts.
if he is refusing to obey a valid exit order and he's moving around, why do you need more? I mean, can't you sort of, under those circumstances, presume he's up to no good?
Well, I don't think, not under the facts that were brought out here. Again, if they develop this and it's, you know, we looked eye to eye to him, you know, we shouted in the window, he understood what we were saying, he didn't comply for over 30 seconds or a minute, and he's moving around, you know, making really furtive, suspicious movements of trying to conceal something or trying to swallow something, then you may have it. But without those type of facts, just kind of conclusory statements that aren't developed, that he began to move around and didn't comply. We don't know how long he didn't comply. Again, he's kind of caught off guard in this situation. He's sitting in a car in a residential neighborhood. He has no idea that there are anyone, you know, four police officers are going to approach his car. You can freeze in that type of situation. I'm sure that, you know, that's part of human nature in some people. So
can you move to the next two steps, because we've spent, you started saying you would talk about the second two, and we've spent a lot of your time on the first one, but I'm interested in what happens next and then what happens next.
Okay, and then so he's forcibly removed, he's handcuffed, the car is searched, he's searched, nothing's recovered.
What is required to permit the search of the car and the search of the person?
Probable cause to arrest. Therefore, you have a search incident.
So you view these as, that is, these are only okay if they're valid searches incident to a lawful arrest.
Right. That would be, you know, the rule is a warrant. So this is the exception to the rule to do searches like this. So one exception is the search incident to arrest based on probable cause.
And can you tell us the exact order things happen in?
As far as
well, I know they call the phone and it vibrates at some point, and I'm not clear on when in the sequence of events. Is he in handcuffs at that point? Has he been pat frisked? And
you're right. My understanding is that we know that he's out of the vehicle and handcuffed at the time that they enter the vehicle. I'm not sure of the order of the pat frisk versus when they see the phone vibrating. But nothing is produced in the pat frisk, and that's an important point in this case. And our second point is, because they are able to now search the car, search his person, and turn up nothing, that they then cannot continue to detain him, formally arrest him, transport him to the police station to be charged with possession of drugs, where there's no evidence of drugs. There's no evidence that he concealed the drugs.
Is he actually charged before they even find the drugs? Is that right? Or other way around?
He's not formally charged, I guess, until he's booked at the police station. But he was put under arrest and read his Miranda rights. And once you're detained like that and transported to the police station, you're under arrest.
No, I'm just trying to figure out, they pat frisk him and find nothing.
Right.
But eventually drugs are found where? In the pocket of his hoodie or something?
That's right. My understanding is the front pocket of a hooded sweatshirt. If you're
are they arresting him for possession, or are they arresting him for being the person who provided heroin to this woman who just overdosed?
Well, they have no evidence that he produced the heroin.
Well, they have some evidence. He's the last person on her cell phone, and when they say, "I need some more," he comes.
Right. Well, that gets to the text messages too, which I think is another important thing to talk about a little bit. Is we don't. And here's another kind of, I think, hole in what the Commonwealth needs to show. So, okay, that they decide that the last person she texted is the person that sold her heroin on a previous time. We don't know what any of those previous text messages between Mr. Arias and her were about. We have no information whatsoever. And then we have the text messages themselves that don't talk about any drugs. They don't use coded language for drugs. There is she texts, or the police text as the decedent, looking if you can hook me up. And he replies, hook you up? Question mark, question mark, question mark. That indicates confusion to me on the part of Mr. Arias. What are you talking about, hook you up? Then she says, yes, I got 100. And he texts, I'm on my way. Now, we make a point in the brief with text messages. This happens to me. I don't know if it happens to Your Honor. When you're in a conversation with someone, you text something, but in the ether, a different text shows up. Put that aside. This I'm on my way could indicate, as we say in the brief, that, oh, you've got $100. We're going to go do something. If you want to say it's nefarious, okay, we're going to go together to go buy drugs. But that's not a crime. That they don't have any crime there until something happens. So I don't think they had evidence that he sold her the drugs that killed her. I don't think they have reasonable suspicion, let alone probable cause at this point, that he is the man. I know it doesn't matter for our analysis, but my understanding is she OD'd on Suboxone, which was not anything that was ever found on Mr. Arias in this case. Thank you.
Thank you very much. Your time has expired. We will hear now from Ms. Cusick.
Thank you, Your Honors. May it please the Court. Tracy Cusick from the Norfolk District Attorney's Office on behalf of the Commonwealth. Your Honors, the conviction should be affirmed because here the motion judge correctly found that reasonable suspicion allowed police to stop the car that showed up in response to text messages about drugs, and that reasonable suspicion ripened into probable cause to arrest him. The police had used the phone of the deceased woman. She had died only hours earlier to text the last person she'd been in contact with to arrange a narcotics transaction. And in the transcript of the motion to suppress hearing, there's also a reference to $100 being the cost of a gram of heroin. So whatever confusion might be about what the actual text messages were with his question marks, one inference would be, what do you mean, hook me up? What do you want? And when the $100 was texted, then the defendant texted back, on my way. The defendant arrived at the scene, and again, the car circled and then came back, and simultaneously a text message was received by the decedent's phone. I'm here, I'm here. And at that point, the police approached the car as they had certainly reasonable suspicion to conduct a threshold inquiry. And then the defendant stayed in the car, in the locked car. Again, the record reflects it's about 6 o'clock in February. One can infer it was dark at that point in time, and the police see him moving about. So certainly, as the motion judge found, there really wasn't an alternative to breaking the window to getting him out. I mean, certainly calling a locksmith, a lot can happen in the time it takes for a locksmith to arrive. And again, the defendant is in an automobile, which he could certainly have put the car into drive and gone somewhere. Police were faced with this situation. As the motion judge found, it was reasonable to remove him from the car.
Yeah, but they didn't find, well, go ahead.
My question was, thank you, Judge Milkey. When they, at this point, when they decide to remove him from the car, you're not saying they had probable cause at that point. You're saying this was proportionate to effect, they had reasonable suspicion, and this is proportionate to effectuate the exit order.
They may have had probable cause to arrest, but all they needed was reasonable suspicion. And I think
don't they, in the end, need probable cause because they didn't find anything at that point in the car or on his person? And certainly when he's being taken back to the police station, he's under arrest, correct?
That's correct, Your Honor. He was under arrest when he was taken back to the police station. But certainly,
how do you get probable cause out of this? Let's say we were to agree with you that there's reasonable suspicion. I mean, we have this person whose first response to hook you up is like, hook you up. Then she says, I have $100. You say that's what heroin costs. Lots of things cost $100, and she's got $100. So he's on his way. Maybe he's on his way to sell something to her. Maybe not. We don't know. But okay, reasonable suspicion. And he shows up. How do we get to probable cause to arrest this person when the threshold inquiry produces nothing of any new value?
Well, the threshold inquiry produced also the phone vibrating in the.
Of course, the phone's vibrating. They had texted the phone, and this is the guy who showed up. His car is out in front, and he texts from that very number, I'm here. So it can't have been a surprise to anyone that one of the phones in the car vibrated. He had texted from it moments before. He's the only one there.
Well, the police didn't know for sure that it was.
Okay, so now they know for sure this is whatever the guy's name is on the tag. I don't remember, Ricky or something.
Rocky. I think it was Rocky on the.
Rocky. All right, so that's Rocky, but that's not probable cause that he sold her drugs.
Well, it's not necessarily that he sold her drugs previously, but he was charged with possession with intent to distribute.
You didn't find any drugs until later. You did a threshold inquiry, and it seems to have turned up nothing. I'm not sure why the police were allowed to search his person, but they did. Is that search incident to an arrest? Is that your defense of that?
Incident
to arrest for weapons? What is it?
That would be a search incident to his arrest.
So he's already arrested before you search him. So you have to, I mean, unless we think that the vibrating phone kicks this from reasonable suspicion up to probable cause, and you've heard that I'm skeptical that it really adds anything in this circumstance, you sort of have to have had probable cause right when he showed up, because he's arrested as soon as he's removed from the car.
Well, Your Honors, I'd suggest that here we have the text messages going back and forth with the phone. We have a person who's deceased. So a reasonable inference is this isn't marijuana or some sort of.
No, she took a fatal overdose of, well, if it's Suboxone, I don't know. Let's assume she didn't have a prescription for it. And she took a fatal overdose of something. And the police have, maybe it's good police work, have texted the last person she talked to, but we don't know that the last thing she did before dying of the overdose was interact with the seller. We don't know how long the drugs were in her house. We don't know all of this stuff. I don't know. I just have a hard time getting to probable cause.
Well, at the time, he was not charged with providing the drugs that caused her to die. There was nothing to connect him.
But if I text someone and say, can you hook me up? They write back, hook you up. Let's say from any drug purchaser's phone, we've arrested a user. We text the person they last were in touch with, could you hook me up? They write back something that really does seem to convey confusion. Now, maybe the confusion is, who says hook you up? Are you a cop, right? Or maybe that's not how you talk. You hook you up. What, I have no idea. But it could also be like, hook you up with what? Like what? And then you say, I have $100, and they say, okay, I'll come over. I'm on my way. Surely we can't arrest every person who does that for possession with intent to distribute, right?
In these circumstances, you could arrest this defendant. Again, showed up, circling, right there in the.
No, of course he showed up. He said he was on his way, and then he showed up. Right? I mean, none of that's a surprise.
Then the police attempt to conduct a threshold inquiry, doesn't get out of the car, keeps himself in the car, moving around.
All right, that's suspicious, maybe.
They take him out of the car, and perhaps I misspoke earlier. Maybe the search, it's not clear in the record but of the timing, but he was removed from the car, pat frisked, possibly for officer safety. There's no mention.
They didn't find anything. If they had found drugs, then we'd have to sort that out. They didn't find anything. Right, the purpose of the threshold inquiry is to confirm or dispel suspicion, and certainly nothing confirmed. I don't know if it dispelled, but it didn't confirm.
Your Honors, in this case, they did find the drugs later on, but that doesn't affect really what happens. But the fact that they didn't find the drugs when they immediately searched him Again, there are other cases, some by this court, I'm sorry the name is escaping me right now, where the absence of drugs at the time of the arrest doesn't mean you can't be charged with possession with intent to distribute. And I do reference those cases in my brief. And I'd suggest that's the situation here. There was certainly probable cause to arrest this defendant, maybe not enough at that point in time for proof beyond a reasonable doubt, but there was certainly probable cause to arrest him at that point in time. And I would certainly suggest this was not a traffic stop. This was not a motorist with a taillight out or something else. It was certainly ample reasonable suspicion for the threshold inquiry in this case. And again, the defendant's actions at the scene in not getting out of the car and then confirming that he was indeed Rocky, the person who the police were texting with, I'd suggest that there was probable cause to arrest this defendant and that the motion to suppress was properly denied.
So in the text, there's no explicit mention of drugs. It's just hook me up and I've got $100.
That's correct, Your Honor. In the transcript, there is a reference in the police saying that $100 is the price of a gram of heroin, but there's nothing else to explain that conversation.
I know it's not relevant to our inquiry. What was the volume of drugs found on this guy?
It was a small quantity, Your Honor. I don't remember the quantity exactly, but it was a small quantity.
And are we here under Gomez? He pleaded but reserved his rights. Is that what we have here?
That's correct, Your Honor.
And did he plead to intent to distribute?
Yes, Your Honor.
Okay.
Just to clarify for me, assume he had complied with the exit order. So they have reasonable suspicion. Can they search him for drugs at that point on reasonable suspicion?
Yes, Your Honor. I believe they could have searched him for drugs at that point.
That's it. So that like Terry and his progeny would go that far?
Yes, Your Honor. It's a threshold inquiry, and again, they had ample probable cause based on the timing of his arrival.
Well, but what if they didn't have probable cause? What if they only had reasonable suspicion?
Even on reasonable suspicion, they had reasonable suspicion to search him.
There's no reasonable suspicion search except for armed and dangerous. The way I mean, I may be misremembering, but right, a reasonable suspicion pat frisk is for armed and dangerous only. It's a stop for an inquiry under Terry. Now, obviously, those can escalate into something more where you get probable cause to arrest. But I may be mistaken, but I don't think you can search someone for drugs without probable cause.
Your Honor, I believe there is a basis to search where they're looking for evidence of drugs. I believe it's in the Cruz case, is one of the cases in the Commonwealth's brief that says there's 3 reasons you could do something like that. And I'd suggest that this search was justified as part of a Terry inquiry.
So how do you address your brother's point that we don't know how long he apparently refused to get out of the car? You know, is this a 1 second gap, or is this a Justin Trudeau 21 seconds? Doesn't it matter?
Your Honor, I'd suggest it doesn't matter, but I also did look at the defendant's affidavit in support of his motion to suppress. It doesn't contain any claim that I was trying to get out of the car and the police smashed the window before I could.
No, the burden is the Commonwealth's.
Yes, Your Honor, it is. Yes. But Your Honors, we don't know what the timing is, but again, given it's a dark night, the defendant the car arrives and the police are looking to search, conduct an inquiry of a suspected drug dealer. I'd suggest that the timing is immaterial here. If there were no further questions, I would rest on my brief.
No, seeing none. Thank you very much. Excellent arguments, both of you. It's an interesting case, interesting set of facts. The case is submitted, and morning is number 19-1374, Hoy v. Hoy. I will just remind counsel that we are live streaming this, and also a video recording of it is being archived. So you should just be aware your camera may be on at all times, will be on at all times, and your microphone as well. And there is no appearance by appellee, so we will hear from Mr. Vitale.
Good morning and thank you. May it please the court, my name is Richard Vitale and I represent Carolyn Hoy, the appellant. Ms. Hoy says that the trial judge's judgment is not supported by the facts of her own findings, nor is it consistent with her findings as facts. Specifically, there are three areas which the appellant wants to present. First and foremost is that when the judge came to deciding the coverture period, she did not follow her own findings. I can explain that more. Secondly, when she divided the real property at 82 Robinson Street in Lynn, which was in my client's name, she divided that property, we say, disproportionately. And lastly, the trial judge found that my client, every time she gets a 5% pay increase, should have to notify Mr. Hoy. So we contest that finding as well. Ms. Hoy, as you probably know from reading the paperwork, filed for a divorce when she was facing a foreclosure. Ms. Hoy owned this property at 82 Robinson Street for years, including 3 years before she married Mr. Hoy back in the early 80s. She contributed $18,000 towards its purchase. Ms. Hoy filed for a divorce back in 2004. Then she stopped that divorce for the sake of her child. And then she and her child eventually separated from Mr. Hoy. And she moved upstairs at 82 Robinson Street and then finally vacated 82 Robinson Street in 2011, October of 2011.
Did she vacate? Mr. Vitale, did she, when she vacated, she take her child with her?
She took Cameron with her, the child. Yes. Yes. He resided with her. They moved first to her mother's house, then they moved to an apartment. When the year 2017 rolled around, she was experiencing severe financial problems. She was using her credit cards to make do. She was paying rent, and she fell behind in her rent, but more particularly, she fell behind in her mortgage. And the U.S. Bank began to start a foreclosure, and facing that foreclosure and the prospect of losing 82 Robinson Street, with losing any equity in the property, and also having Mr. Hoy be ejected by the bank, my client, Ms. Hoy, acted to preserve the equity. She filed for this divorce, and in the process of filing for the divorce, she obtained an order to sell the property. She obtained that order to sell the property, and Mr. Hoy was ordered to vacate within 30 days. He did not.
Mr. Vitale, our time is limited. Can I?
Sure.
We know what happens. They sell the house. There's a $30,000.
Right.
Is all that's left, and the judge divides it 2/3, 1/3. Mr. Hoy gets the 2/3. Your client gets the 1/3, and you think it should be the other way around.
Right.
Right. Can I ask you about you also say, so on the coverture period, I'm looking at your brief, the bulk of the IRA, there's an IRA and a 401k from her first job at Quinlan, right? The bulk of the money is the Quinlan stuff. She left Quinlan in 2006, right?
Yes.
So any appreciation of that was just appreciation. She's no longer contributing to those two after 2006.
No, those funds were put into, or her retirement funds were put into an IRA, which have attributed some interest and earnings over the years.
Right. I mean, isn't the husband entitled to share in those? She's no longer contributing after 2011. Isn't he entitled to share in the interest?
Well, I guess the question is the period of that, Your Honor, and it's undisputed that Ms. Hoy was contributing only to the marital assets and to Robinson Street after she vacated, and Mr. Hoy didn't contribute at all.
Right. No. I'm giving you that. I'm giving you that.
Yeah.
So 2011, she actually is generous to him. She gives him, she contributes to it so he can live and not be homeless. Very she's, you know, right, she doesn't have to, she does. But this asset, this main asset here, is something that was acquired and fully owned by both of them up to in 2006.
Well, it was acquired when they were married in 2006. Correct, Your Honor. Yes.
So she hasn't contributed to it from 2011. It's just appreciation of income. If they
Oh,
got
that's
divorced
correct,
in 2006, he'd be entitled to the income.
Right.
So the only thing, I'm sorry. So the only thing that there's this other $20,000 from Rickenbacker, and that she was contributing to after 2011.
Yes.
Okay. You know, so she made an argument for he's not entitled to any contributions that she made after 2011 to that one, but he's certainly entitled to the interest from the other one.
Well, I guess to what point, and we're suggesting that the trial judge went to the date of the divorce, not even the date that the complaint was filed, which was a year earlier. And we say it could very well have been when she vacated and they separated totally. It's undisputed they were apart in 2011.
If the judge had chosen the date of filing or serving the complaint for divorce, which is the date, the serving, I think, is the date that's used for figuring out the length of the marriage for purposes of, is it short term, is it long term, and so on. Would that have been an abuse of discretion?
I still think so, yes, Your Honor, given the set of particular circumstances here. I mean, this is an extraordinary contribution. This isn't, the court is right in terms of, you know, the history, but this is when you weigh all the facts, Your Honor, this is above and beyond contributions. She paid for virtually everything, even the dog food. So this is, I think, takes it out of the realm.
The concern I have is really what's unusual about this, if there's something unusual. Well, it's unusual. The wife's extraordinarily generous to the husband despite moving out, extraordinarily generous for 6 years after moving out, maybe more. I don't know when she stopped supporting him, basically. But a husband might do that with a non-working wife. And I don't think we'd say that the husband gets to keep everything that he earned afterward if he's continuing to contribute to the marriage, right? At least I don't think we'd say it was an abuse of discretion to say, look, this is a husband and a dependent wife, and he continued to, sure, he moved out, but he continued to support her. They stayed married. He didn't file for divorce. I think we might say, look, we're not going to say the marriage was over until it was over. And that's sort of what the judge has said here. And I'm just nervous about saying it's an abuse of discretion when someone true out of generosity, I don't want to deter people's generosity, but she didn't divorce him until 2018, and she continued to support him.
Well, she continued to support him because she tried to save the equity in the house. She
sure,
also
but
was
also,
caring for her
look,
son who was living there.
She sounds extremely decent. Also, it's her son's father who wants him on the street for reasons that we don't fully understand, or I don't at least. He's not working essentially at all, and so on. I don't know if it's because of disability or not. It's very hard for me to figure out. But she is being incredibly generous. But the question is it an abuse of discretion essentially to say these people are still married?
Well, I think they were married in name, but
yes,
I think it's fair to say that they were, as of October of 2011, there was no relationship.
Well, I don't know. I mean, she's sending him money.
Well, she sent him money as part of being the generous, even after the sale of the property or the sale of the property was imminent. You know, she paid to put his stuff in storage. She paid other bills for him. The real estate broker did the same thing. I mean, this is a case where she did everything right. And I think the trial judge actually says at some point, you know, that my client went by the book. Well, she went by the book and did everything right, but the result is wrong in our view, Your Honor.
Can I ask you, you filed just a couple days ago, you filed a copy of the husband's answer. Why did you do that?
The court asked me for that, Your Honor. Apparently it was part of it's docketed as it was filed on the docket sheet, Your Honor. But when you go there, I didn't know this myself until I went there after the court contacted me, and the answer is not there, Your Honor. There was another pleading that was recorded twice. So the court called me and asked me if I would send in the answer. Okay.
So, I mean, the judge says, you cited a part of the transcript where the judge says he could have filed for alimony, but earlier in the transcript, she says, you filed a counterclaim in this matter. You asked for alimony, and the answer that you gave us, it's got the word alimony there, written pretty big letters with. In fact, he's so emphatic he puts an extra L in it. Isn't that good enough as a claim for alimony?
Your Honor, he did not file a counterclaim. He filed an answer. He wrote out a bunch of things in that document, Your Honor, some of which were derogatory to my client, some of which were not relevant, I suggest. But he clearly, Your Honor, at no time asked for alimony formally. I mean, that the word alimony is undisputed, is there, Your Honor. But there was a part I didn't mark in my brief, Your Honor. But at the end of the trial, if you give me 1 second, Your Honor, on page 66 of the transcript, on page 129 of the transcript, Your Honor, lines 9 through 11, the court's wrapping up, and the court says, in terms of alimony, what is it you say? And Mr. Hoy answers, again, I'm not sure. And he prior said he was not sure what he was looking for, Your Honor. So I mean, other than the word alimony appeared in that, Your Honor, that would be the only claim I would say you could possibly consider, but I don't think you should consider, because again, it was in a disjointed answer filed, way before the trial. And when asked at the trial, he did not acknowledge he was looking for alimony, and the trial judge herself said he could have filed for alimony at prior times, but did not.
Okay. One more question. It's true that under Section 34, a judge can award property in addition to or in lieu of alimony, right? And here the judge decided not to order alimony.
That's correct, Your Honor. Yes.
So could that be a reason for why she decided to give the husband a little bit more from the house? I mean, she did her best to not to lose the equity, but there's not much left after at the end of the day. She gets her expenses back.
Well, I think the trial judge in her rationale, Your Honor, does go to that point. I would suggest, Your Honor, under 2A34, under the conduct of the marriage, Your Honor, you can consider the economic impact, and also, Your Honor, as other factors, you can also consider the preservation, the maintenance, and the actual payment of contributions. And so I think the judge, was trying to say about the alimony. But again, that issue of the alimony, one last point I'd like to make, Your Honor, is that other than the division was not equal, Your Honor, she also imposes, the judge does, that my client has to notify him every single time she gets a 5% increase. She's making $400 a week, Your Honor. So a 5% increase is $20. And she gets another raise. So this is a never-ending cycle of reporting and trying to contact him when a part of the divorce, not exclusive from her fact about the foreclosure, was she finally had it with him and wanted to get away from him. He had been abusive in the marriage. There were other issues in the marriage, Your Honor. So the goal of getting a divorce and being separate from him, it seems like she's tied to him for forever now, Your Honor. If there's nothing further, Your Honor, I just would wrap up and just make the point I tried to make, is that the judge herself made admissions in the post-judgment hearing, Your Honor, that my client was the one who went by the book. it's our position, Your Honor. My client did everything right. I think the judge in the transcript also says that my client took the moral ground. And I think the court has recognized my client's contributions in doing the right thing, Your Honor. But it seems to me and to my client that after all of the efforts and everything she's done to have this decision stand would be not just. And she's asking the court, Your Honor, to take, Your Honors, to review this and with a mindset that the findings of fact are inconsistent with what the judge ultimately decided.
All right, if there are no further questions, thank you very much. An unfortunate case, as these all are. Thank you for an excellent.
All right, we are live.
Thank you very much. Our next case is number 190802, John Doe number 524474 versus the Sex Offender Registry Board. I'll remind counsel that this is an impounded case and that you should not use names. It's 15 minutes aside, and I would also just remind you that this is being live streamed and a video recording will be archived, and consequently your microphones and cameras, to the extent applicable, may be on at all times throughout the argument, even if you're not speaking, and you should just be aware of that. We will hear first from Mr. Stiles.
Thank you. Ethan Stiles for the petitioner. The petitioner in this case asked for funds for an expert, and he's here today because that motion was wrongly denied by the hearing examiner. The hearing examiner had to give serious consideration to Mr. Doe's motion for funds because it implicated Factor 35, which is psychological or psychiatric profiles indicating risk to reoffend, and we find the support for that in the Doe 89230 case. The hearing examiner indicated that he denied the motion because the updated regulations addressed the issue of substance abuse, but he didn't consider the raising of the Factor 35, which was discussed significantly toward the end of his decision, and ultimately his conclusion was in fact based upon that. Now, there's nothing to consider to indicate that the board had any particular expertise in the issues that were particular to Mr. Doe, namely schizoaffective disorder or cannabis-induced psychosis, according to the reports from the doctors that were submitted in this case, or even how to diagnose and treat those disorders. So we have an issue of the courts have said that a hearing examiner might greatly be affected by expert testimony, especially testimony that would be tailored to the needs of the hearing, whereas the reports here were tailored for a different purpose. And I think that would have been an issue that should have been raised and addressed in a more appropriate fashion if to rightfully deny the motion. Now the question is going to.
Can I ask you a question?
Of course.
I was going to ask you, what is your understanding of the standard that a petitioner has to make to be entitled to expert funds? And you just mentioned something tailored for the needs of the hearing. So what is the standard? And does that language come from one of the cases?
Well, I think it also not directly, Justice Massing. The standard is that a petitioner has to identify a condition that's specific to him, and testimony which would be helpful to the hearing examiner. But when I say as a practical matter, if you're going to ask for funds for an expert, obviously the defense, the attorney for the petitioner believes that testimony is going to be helpful to him, and on that evidence, and so he'd want to have a report and testimony from that person at the hearing in order to present the best case for for the position he's trying to make. In this case, that cannabis-induced psychosis or schizoaffective disorder is not going to be is not a serious issue that that the hearing examiner needs to consider in his evaluation of risk. So I think that and I think it obviously in this particular case, had the motion for funds been granted, I think that the petitioner would have sought the assistance of Dr. Stein, who wrote the more lengthy report, and who was also an expert evaluator for sex offenses as well. Being a qualified examiner, I'd expect him to opine on the risk of reoffending generally, as well as discussing the issue with his cannabis disease. So now I think the most, the hearing examiner did say that these two doctors stated that if the petitioner is not using marijuana, then the likelihood that he would reoffend is low, essentially, because this was the only sex offense on his record. It was a one-time, one-day offense, and while he had previous episodes of psychosis, that they did not involve sex offenses, and there was also a particular a relatively lengthy period of time where he was stable in his life and did not acquire charges or get caught with marijuana. So I think ultimately the experts would address issues of treatment here, and I think that's probably the biggest unknown that we have before us is are issues related to treatment. And I think that would have been one thing that the expert would have been most helpful on, because I do not believe, despite the Factor 9 being in existence, that the board is an expert on treatment, especially for rare and unusual cases such as cannabis-induced psychosis or schizoaffective disorder. So when I do focus in my brief more on treatment than perhaps my predecessor did, I'm thinking toward the practical questions which would be asked and which we expected to be answered by the expert. And so I think that unless there are any further questions, let me move on to the second issue. And the second issue deals with issues applying the factors. And the first one is the issue of the stranger versus the extrafamilial victim. And I would suggest the evidence that was presented here gives a case that the expert wrongly considered the victim to be a stranger. That the police report, in the police report, she calls him a customer. She says after he makes the first pass at her to get your donuts and go, which coincides with his own reports to his treatment the petitioner's own reports to his treatment providers that he was a frequent customer of that establishment, and so that if she knew what she had to order, that was just that he was familiar with him and he wasn't just going up to random people asking them for a hug.
So,
And
Mr. Stiles, can I ask you again? We don't have a copy of the transcript of the hearing. Is that correct?
I don't. Actually, I did look at that when I was preparing for oral argument, and it appears that may not have found its way into the record appendix volumes. And if that was so, Your Honor, I apologize, but I think that may have been a technical issue. We're trying to file these things electronically and try to fit everything into 25 megabyte slices, and I may have overlooked that. But I think what I think you were trying to ask me was there was no testimony given at the hearing. It was just argument.
I mean, what my question is, how is the hearing examiner supposed to comb through the entire record to find evidence, in the police report that there's one mention of him being a customer, or isn't that something that counsel has to bring to the hearing officer's attention?
Well, I think it would ideally be, obviously, I think it would be helpful if counsel did, but I don't think that he can necessarily anticipate what the hearing examiner is going to look at or not look at. But I think the report, which is included in the record appendix, is about a page long, maybe a page and a half, and I'm sure it was reviewed at some point by the hearing examiner.
Counsel, isn't there a threshold you have to cross to make someone not a stranger? I mean, in terms of the distinction between stranger and non-stranger, wouldn't a non-stranger be someone with a certain, significant relationship? It doesn't have to be, a close friend, but a customer seems to be way down the spectrum, far from even an acquaintance.
Well, Justice Milkey, I don't think it requires much to be by the regulation to be to rise from the level of stranger to extrafamilial. I think it said stranger victim, any person who was known for less than 24 hours who has had no memorable interaction with the offender. So I think in terms of I think when there's a regular customer, I think that you could make that there is the argument that this person rises above the level of a stranger, if not due to the great amount of interaction, but the frequency of casual interactions over time, that someone would recognize that person, maybe not by name, but by sight, and so there would be a level of familiarity between those people that would separate them from a random stranger. And I think that's what the regulation is trying to get at.
I mean, if the person comes in every day and the extent of the interaction is, how much is this coffee, would that make someone not a stranger?
I think under the terms of the regulation, I think it could, because I mean, ultimately, with regulation deals with some level of familiarity. I think you have to distinguish between random person or person that was, essentially maybe a customer once or twice versus someone who maybe, who actually does that sort of thing every day. Say hi, how are you? Good, how are you? And the ordinary, interactions that people have with the person who regularly takes their order. I think so. I think that would rise above the level of a stranger. The other issue that I talk about is the issue of treatment availability. Now, I cite to the analogous case of Doe 5 of the Doe 151564 case, where in that case the court held that that treatment was not when it was not available or required, that the hearing examiner should not consider it against him. Now, obviously, that was talking about sex offender treatment, but still, and here the issue might be of substance abuse treatment, but still, I think the same thing applies. That if you looked at the docket, it would show that the petitioner was on probation, and there was no issue of him being not in compliance with the terms of his probation. So if the probation did not require treatment, then I don't think that could really be seen against him, because that would be something that would seem to be unfair to him if it were not required and he did not do it. And again, that also touches based about my point made for the first argument that expert testimony would be helpful on this subject. So ultimately, if you consider that these two applications of the factor were error, you have to look at what remains. And I would suggest what remains is not a level 2 classification. There's only, there's fairly minimal violence in this record. There's no serious criminal cases.
There's three. What about the 3 different women who seek 209A restraining orders against him?
You can obviously we take that into some consideration, but
they had to show a reasonable fear of imminent physical harm from him, or we don't know what. Do we know what the basis of any of those 209As was?
I'm not sure how much we know about them. I think there is 1 or 2 in the record appendix, but I think they're handwritten, so they're somewhat difficult to read. But ultimately, yes.
You're saying there are two, including the affidavits?
I believe so, Justice Milkey, that there were one or two, and yes, there looks to be at least there's at least one affidavit in here, and ultimately, yes, and I take the point that that they have to that they have to have a reasonable fear of imminent harm, and that's worth some consideration. But if the charges do not arise beyond, from fear of harm to actually being harmed, I think we need to take that put it in its proper context. Which
Do you have a citation for that affidavit?
Yes, Your Honor. You can find the affidavit in Record Appendix Volume 2 at page 23. It's handwritten, so.
We don't need to take your time with it. We can have a look.
All right. And I believe that, and I believe that might be the only one that was made available. But ultimately, I also feel that the hearing examiner did make some what may have overstated the number of probation violations in his record, which could also be found in the same volume a few pages back. But ultimately, I think that if you take away, the stranger is perhaps the most probably one of the most worst of the factors to consider. If you start taking away factors like that, then I think the court needs to give serious consideration as to whether the remaining factors are worthy of a level 2 classification and its requirement for public dissemination. So with that, if there are no further questions, I will rest on the brief.
Thank you very much. Your time has expired. We will hear now from Ms. Nixon.
Good morning, Justices. May it please the court, Nicole Nixon on behalf of the Board Appellee. Turning to the first issue in this case, which is the hearing examiner's denial of the motion for expert funds. It's the board's position that the hearing examiner properly denied that motion because the petitioner here failed to meet his burden of demonstrating a particularized need for expert testimony. And that's my understanding of the threshold burden a petitioner would have to meet in his motion for expert funds. I believe it's clearly laid out in DOE number 89230. That burden. I believe there's a regulation as well that states the threshold burden that petitioner would have to meet for a motion for expert funds as well. And it's the board's position that that burden wasn't met here. Although the motion identified a mental health diagnosis, specifically schizoaffective disorder, the motion did not tie that diagnosis to any risk of reoffense or degree of danger. Now, my brother makes mention of
isn't that why he needed an expert?
Well, I believe what my brother points to the need for an expert testimony in this case is to bear on how treatment for his mental health issues as well as his substance abuse addiction would have reduced his risk of reoffense and degree of danger. But here the record is, there's nothing in the record to show that Doe was actually engaged in any sort of treatment for his mental health issues or his substance abuse issues. So any testimony about treatment would have been purely speculative in this case and irrelevant to his risk of reoffense and degree of danger. And that's really the crux of this case, I think, is that if we're looking at the need for expert testimony here, and my brother is saying that the need would be to show how a treatment regimen, whether it be therapy or whatever, would have reduced his risk of reoffense and degree of danger because it would have helped him address his mental health issues as well as substance abuse addiction. There's nothing in the record to show that he was actually engaged in that treatment here. So any testimony as to treatment and how that will mitigate his risk of reoffense would be purely speculative.
Isn't there the same chicken and egg problem identified by Judge Massing? If we don't understand this condition, how can we show the pertinence of it to this case?
Well, I think, Your Honor, the hearing examiner looked to the reports in the record by specifically Dr. Stein and Dr. Crane. And in both of those reports, both doctors pointed to Mr. Doe's issues with marijuana use and how those issues of marijuana use triggered his maladaptive behavior. If you look at both of these reports, when Mr. Doe is not using marijuana or abstaining from marijuana use, his behavior is normal and fits within the norms of society. However, specifically in this case, when he had used marijuana for a lengthy period of time, that is when he offended. And I don't think that the hearing examiner, excuse me,
I'm sorry, you go ahead.
I don't think the hearing examiner needed expert testimony on that, where it was laid out in the reports, and anything more that an expert could have provided, meaning any treatment regimen that could have reduced his risk of reoffense by helping him to engage with his issues with marijuana use, would have been speculative.
Do you agree that the question here is whether he is likely to sexually reoffend?
I do. I think the risk of reoffense should be on sexual reoffense, because that's the analysis that the hearing examiner has to undertake.
We have Dr. Stein saying something that I don't know if I've seen in a SORB case before, which is that these crimes were not triggered by an interest in sexual gratification. Rather, I guess he's out of his mind or something, right? I mean, he obviously can't control his behavior, at least when on marijuana. And I don't think it goes too far to say there's some substantial likelihood that if he keeps smoking marijuana, he's going to do something. But you don't think an expert might have been helpful in talking about, is it going to be something sexual? I mean, this is a man who at age 37 committed these 2 crimes. I mean, plenty of criminal history. You know, I get why the factors come out the way they do. But at age 37, for the first time, he commits 2 sexual offenses, if you want to call mooning people a sexual offense, which I know it's in the definition, but there's something, right, that's a little different than we usually see, even from, gross lewdness or whatever.
That's true.
Although obviously grabbing a buttock of a woman is a contact sex offense. I don't minimize that at all. You don't think an expert might have shed some light on that question?
I don't think so here. And I think we have to look at the report from Dr. Stein and how it was, or the reason why it was compiled. It was compiled as an aid and disposition report for his criminal sentencing. And he did make that finding. However, the fact remains that he did sexually offend while he was in a state of psychosis induced by marijuana. And we have to deal with that fact.
No, I agree. But the whole question is, how likely is he to sexually reoffend again? And we have someone who has been offending for 20 years and then, did, as I say, the assault on the person who worked there is, in my mind, more serious than the mooning, which obviously I also don't love, but it's not dangerous exactly in the same way.
Sure, and I understand your point, Justice Rubin. However, I would state that expert testimony, specifically from Dr. Stein, to say as to whether he would likely sexually reoffend in something if he goes back into his marijuana use and resorts back to this maladaptive behavior.
And Dr. Stein opined that he was likely to sexually reoffend, not just reoffend, because I think he is likely to reoffend, but sexually reoffend.
Yes. I'm sorry, I don't really understand your question. If you could just
well, I mean, I could ask a person, is X likely to reoffend? And the answer might be, yes, he assaults people, he waves guns around, he commits terrible crimes. Is he likely to sexually reoffend? I don't know, much less likely, he never did it before. You know what I mean? Does Dr. Stein specify sexual reoffense?
Sure, I take your point, and I don't think that the point of his report was to bear an opinion on sexual reoffense. I think what he states in his report, which is in, I believe, volume 6 of the record appendix, is that what he did, his grabbing of the victim's buttocks, wasn't for sexual gratification in this case. It was a result of his use of marijuana and his behavior, I guess, how that marijuana use affected his behavior in this case. So I think that's an important distinction here. He wasn't making an opinion as to Mr. Doe's likelihood for sexual reoffense. He was stating that he believes he did this act in this case because of his state of being at that time, and not specifically for sexual gratification.
Now, it's not that unusual to have some relationship between substance use and sexual offending in terms of reducing inhibitions and so forth. What makes this case seem different is the use of the substance actually drives him out of his mind, to speak in lay terms. Why wouldn't a hearing officer want to hear more about that condition?
Well, I think because the reports in the record clearly lay out just what you said, Justice Milkey, is that in this case, marijuana has an especially pernicious effect on this person's state of mind. I'm not sure what else an expert could have testified to that would have benefited Doe in this case. And I go back to I'm sorry if I'm hammering this point, but I go back to the fact that there's nothing in the record to show that he's actively engaged in any sort of treatment to help his issues here. So to the extent that an expert would have testified to something more than what was already in the reports and within the confines of the regulation, specifically Factor 9, that would have been purely speculation. If there's no further questions on this particular issue, I'll move just very briefly on to the next two issues. It's the board's position that the level 2 classification was supported by substantial evidence and a proper application of the board's regulatory factors to that evidence in this case. Specifically, I'll go towards Factor 7. It's the board's contention that the hearing examiner properly found the victims in this case to be strangers. I think it's a leap to infer from the statements within the police report that the victim said that he was a customer and stated to go get his donuts and leave him alone. That means they had any sort of memorable interaction or knew each other for the more than 24 hours, which is the threshold of making somebody go from a stranger to an extrafamilial victim under the regulatory factors. And if you look at the police report, which I believe is in volume 2 of the record appendix, it specifically states that the victim of the contact offense in this case was listed as a stranger victim. So the finding that she was a stranger under the regulatory factors was reasonable and shouldn't be should be afforded deference in this case.
Can I ask you about internet dissemination?
Sure.
Whatever it is,
495-601,
whatever
yep.
it is. Why is internet dissemination called for here?
Sure, I think it's called for here, and I note that there was no specific finding or express finding as required by 496-501, but I think that internet dissemination is required here, and it's specifically or sufficiently clearly laid out in the record because he sexually offended against a stranger victim in a public location.
So
and
is,
that sexual offense,
is internet dissemination always justified where there is a stranger victim and a public location?
Not always. I think here it was a contact offense. That's an important consideration as well. It wasn't a sexually violent offense. And
well, if it weren't a contact offense, we wouldn't be here, I don't think. Because
no,
I think the definition of the danger, I think the court says this, maybe it's in 496-501 itself, that, you know, even a moderate risk of a no danger or little danger offense, using the definition from the SDP cases about, you know, putting someone in fear of contact or whatever, the mooning alone doesn't seem like it gets us anywhere on that,
no,
right?
And I agree with you, and I don't. That's not my argument whatsoever. I think if we were only here because of his mooning behavior, then it'd be a very different conversation. However, he went one step further and offended against a stranger victim by indecently touching her buttocks. And
so, are you saying in every contact offense, stranger victim in public, there is always internet dissemination is always indicated?
No, I'm not saying that. I think you're stretching what I'm saying a little bit too far. I'm not saying that it's always warranted in every single case. I think you have to look at the particular facts of a case to show why it's necessary. And I think in this case, where we have a moderate risk of reoffense finding, which is supported by substantial evidence, as well as a contact offense against a stranger victim in a public location, that internet dissemination is warranted here. And if you look to Doe number 23656, which was a case from the SJC relatively shortly after 496501, it talks about the need for internet dissemination in this type of case where we have a stranger victim, where we have the targeting of a stranger victim in a public.
Can you give me an example of a stranger contact offense, stranger victim in public, where internet dissemination would not be called for?
I think in that situation, it would have to be where there was a low risk of reoffense, or it was something short of what happened here. I think we have to stress that I understand it was an indecent touching and there was no sort of penetration or anything like that, but I think it's still a serious offense. He went to a stranger victim and grabbed her buttocks and did so while she was trying to push him away. I mean, I think in this context, this internet dissemination is certainly required here. If you're asking me circumstances where it may not be required, I mean, I could speculate as to that, but I don't really want to speculate. I think this case clearly fits within the confines of why internet dissemination is required. And if there's no further questions from the panel, I'll rest on my brief. And
one question. I've got one more for you. What facts do we know about the 209As?
So I think if you look in the record, I don't remember specifically. I apologize, I don't remember specifically off the top of my head what the facts of the 209As were. But if you look into the record, there is an affidavit as to one of those 209As. I believe also there's police reports dealing with violations of the other 209A orders that were issued against him. I apologize, I don't have those cites off the top of my head, but I know there are police reports as to his convictions for violation of 209A orders in the record. And if I could just, this just popped into my head, I think what takes this case one step further as to the internet dissemination here is exactly Justice Massing's point as to the evidence of his hostility towards women and his commission of non-sexual violent offenses. I think we have here somebody who has a lengthy criminal record and has established some hostility towards women in the past. I think if in a case where we don't have that, it would be a closer question.
All right. If there are no further questions, Judge, we good? Your time has expired. Excellent arguments from both of you. Thank you very, very much. Our final case for this morning is number 19-1597, Department of Children and Families versus Mother. I remind counsel that this is an impounded case and that therefore pseudonyms should be used or refer to the people by their role rather than their names. I gather the appellees will be dividing their time with DCF taking 10 minutes and counsel for the child taking 5. Is that correct?
That's correct.
Yes, Your Honor.
And I would also just remind you, this is being live streamed and a video recording will be archived, and you should just be aware your cameras are on at all times and your microphones may be as well. And with that, we will hear from Ms. Kornbluth.
Thank you and good morning. My name is Deborah Kornbluth and I represent the mother in this appeal. This is an appeal of the Boston Juvenile Court's decree and judgment that terminated the mother's parental rights to her 5-year-old son and authorized all visits between the mother and her son to abruptly cease. The child's best interest is not served when the process used to make a decision about the child is fundamentally flawed. The child's best interest is not served when the court that makes a decision about the child's interest bases its decision on evidence that everyone agrees the court should never have heard. And when the same evidence violates a parent's absolute testimonial privilege and constitutional right to confidentiality. But that's what happened in this case. The evidence that the court erroneously admitted was salacious, it was gripping, it was highlighted. The court gave it a lot
Counsel,
of—
how was it highlighted? Because, you know, we've all read the findings and rulings, and I'm not sure the defendants, the agency is wrong in saying that this does not appear to have played a major role in the judge's thinking.
That's incorrect. It did play a major role. First of all, as the Flabat cases, both in the appeals court and in the SJC noted, the type of evidence that was erroneously admitted, which had to do with alleged prostitution, was the kind of evidence which usually gets people's attention. That's number one. Number two, finding number 118 was bolded. That was the finding in which the lower court stated that she did not believe that my client did not engage in alleged prostitution. That was one of only 25 findings of fact that were highlighted and bolded. Number three, the witness who testified was the only witness that DCF called who was a non-party witness. She was the only witness that testified to her credentials and whose credentials really became very important. She worked for the Beth Israel Deaconess Hospital, which is a highly respected institution in Boston. And based on those findings alone, or those factors alone, this court cannot say that the lower court didn't give her testimony a lot of credibility and a lot of weight. Additionally, there are many other factors, findings of fact rather, that discussed my client's limited releases of information or refusal to sign releases of information. I can list them for you, but there are many other findings of fact that discuss confidentiality and releases of information. And this court can't say that the lower court's misapplication and misunderstanding of the law regarding absolute privilege and confidentiality did not spill over into many of her other findings.
Okay, I think we understand the argument about this, and we're going to have to sort out the prejudice piece of it. Time is short, though. I wonder if you could talk to me a little bit about the child's behavioral issues. I'm having a hard time sorting out or figuring out if we know or the court below knew what has caused them to deteriorate. Now, I know that there is something in the evidence that says that after she returned, after the mother had the child for a period of time, and then the child went back into foster care, that the child's behavior was worse. I also gather there are these statements about after visits, whatever, I don't know what the right psychological term is, but the child is doing worse, but that's not that frequent. I also note that at some point, maybe you can clarify this for me, the child, having been in a fairly long-term foster placement, is removed. And I gather that has maybe something to do with
pushing other children off the couch or into a glass table or something. And I'm trying to figure out, because I think it bears on best interests, whether the child is in fact getting worse in foster care or getting worse when with the mother, and how these relate, and whether we can figure that out, and whether the court figured it out.
Okay, so as the case of adoption of Kimberly says, this court can, well, the lower court and this court can use the child's presentation and behavior both before he is placed in foster care and while he's with his mother and afterwards. And yes, there is evidence that he became disruptive in the foster home, causing DCF to have to move him. But there's no evidence that shows that was not a direct correlation to him not being with his mother. So before the child was removed from my client, everybody agreed that he had been well cared for as far as his basic needs. He was always well dressed. His medical care was always up to date. His educational opportunities were provided by my client. There was never a lack of supervision. And there's no evidence that shows any of the problems he developed after he went into foster care, such as anxiety, such as alopecia, where he's pulling his hair out, such as the need for psychoactive medications at the age of 5 years old. Now, the lower court can say, I don't believe that he didn't experience any of these issues before he went into foster care, but there's no evidence to show that he did. The only evidence that you have shows that he experienced that type of disruption and that type of anxiety after he was separated from my client.
How long was he in the, oh, I'm sorry, Judge, you go.
No, I was just going to say that there was some evidence of a direct link between the mother's behavior and the child in terms of her being late to the visits or missing the visits. And not only was it documented in evidence that the judge credited that this had a very bad effect on the child, but the mother was told that it had a bad effect and still was late. How do you address that?
I agree. The mother was late to visits, and that definitely appeared to cause the child anxiety. He was looking for her. That's a strong indication that he had a bond with her. He became anxious, and she should have done better. She was told that she needed to be on time for the visits. She was coming from a great, far distance. At one point, it was from Westwood to Hyde Park, all on public transportation. But regardless, she should have been on time. However, her being late cannot be the factor. That's the worst piece of evidence that the department proffered about her regarding her child. All of the other evidence, and I just want to highlight this, the crux of this case really is in the court's 4 to 5 findings, and that's 215, 225, 231, and 246. It's also in one of the workers' testimony at transcript pages 352 to 409. And specifically, if you look at the findings and if you look at the testimony, all of the descriptions by both the worker, the judge, and even the Department of Children and Families in its closing argument talks about the mother's anger, and she couldn't communicate with people. And despite the fact that she had therapy, she still couldn't communicate with the workers, but it's never related. It's never connected to the child. She never spoke badly to the child. He enjoyed, for the most part, he enjoyed his visits. I agree, she should have been on time, but that is not a reason to, number one, affirm a termination of parental rights where she is forever separated from this child. And it certainly isn't a reason for the lower court. Well, the lower court really didn't explain why she rejected the only slim piece of evidence regarding adoption plan that recommended, if the court was going to terminate parental rights, a slow reduction in the frequency of visits, and then eventually to have 2 to 3 times a year. There's no explanation as to why she rejected that. This child was abruptly stopped. The visits between him and his mother were abruptly stopped, and that cannot be in a child's best interest.
Can I ask about the new foster placement? How long before trial was the switch made to the new foster placement? Was there anything in the record about how the child was doing in that placement? I mean, I'll ask child's counsel as well about whether he remains in that placement or what the situation is. I don't know if you know. But I'm trying to get a sense of, did he improve in the new foster placement? Did he do worse or better?
Well, apparently the record shows that he was moved in, I believe it was around April or the beginning of May of 2018. So that would have been about a month and a half or so before the trial started. He was moved to a new placement. The lower court made a finding that even though there was evidence that he was disruptive in the new placement, at some point he settled in and he was doing slightly better. My understanding is that he's not in that home any longer, but I don't have direct information, such that DCF would have or the child's counsel would have. My belief is that he's not there anymore. And under the circumstances where you have such a young child, and I did cite the George Washington University Law Review. He's an African-American little boy. The statistics show that adoptive placements are often much harder to find for such children. He's now 7.
No, I agree. I'll ask opposing counsel about that. Best interests being adoption is one thing if adoption is a realistic possibility. Highly disruptive 5-year-old, it may not be the best candidate for adoption. And I know that the plan said, parents with no other children. And it's like, okay, where, if you can find them,
So, Your Honors, I would ask that you vacate the termination of parental rights decree and remand the case for the lower court to oversee a transition plan, or alternatively, remand the case for a new trial. But in any instance, please, my client would like to have visitation with her child to be instituted immediately. Thank you.
Counsel, I just want to make sure we fully understand your position. It is your client's position that she is ready, willing, and able to take the child back now?
Absolutely.
Okay.
Absolutely.
A lot of time has happened since the trial. Is it fair to assume your client has given birth to her second child?
Yes, it is. Obviously, I'm going outside of the record and telling you this, but she did give birth to her daughter shortly after trial concluded. And she's taking care of her, yes. That child is in her custody.
One more question by way of update. Is the mother, to your knowledge, still living with the sister of the putative father of the second child?
I do not believe she is.
Are you saying, I understand you're saying that she's ready and willing to take the child right now. Is your argument that she was not even currently unfit at the time of trial, or that the prognostication of likely to continue indefinitely into the future and the best interests were in error?
Our position is that there was no evidence of unfitness. There was no evidence of any kind of abuse or neglect. She was ready at the time of trial, and she's ready now.
All right, thank you very much. We will hear next from Mr. Pariser.
Thank you, Your Honor. May it please the court, Brian Pariser for the Department of Children and Families. I'd like to first address the question of the privilege that was raised by my sister. As you're aware, in the department's brief, the department has conceded error in the admission of that testimony at trial. And the reasons for that are considered in the brief. Unless the court has more questions on that, I will certainly rest on my brief. I would say, with regard to the question of whether the admission of that testimony prejudiced the mother, that there's no evidence that it did. The record reflects none. I understand that my sister, yes.
Can I just interrupt?
Yes.
You seem to be arguing that in terms of how we, the appellate court, looks at this issue, we put this issue aside and we see if there was sufficient evidence of unfitness to justify termination. Why isn't your sister correct that that's not the right standard, but we have to look about whether it could have influenced the fact finder's judgment?
Well, I'm not saying that my sister is wholly incorrect in raising the question of prejudice. I don't disagree. I merely argue that there's no evidence that this one error, which resulted in 9 out of over 300 factual findings, constitutes or demonstrates any prejudice. I do think you need to. But in the absence of prejudice, in the absence of any reasonable inference on the record that the trial court was prejudiced, you must then move on to the question of whether or not there is clear and convincing evidence to support the ultimate decree. And with regard to the prejudice question, I would just point out that, yes, there is some bold type in the final sentence. As my sister conceded, of course, that appears in roughly 20 other findings. And it is interesting to note that in every single one of those cases, the bold typeface is used to indicate a determination of credibility, not the substance of the matter, but the credibility of the witness. And so the only thing one can conclude from the bold type in that one finding is just what it says, that the trial court did not believe the mother's testimony, that she did not engage in prostitution. It's a credibility determination along with the other 19 credibility determinations that the court made adverse to the mother's testimony. So there is no indication on the record that it influenced in any way. I understand that prostitution may be a salacious issue, but I would urge this court to go back and review its decision in custody of Tracy.
Does DCF,
yes.
Has DCF ever asserted that a parent actively engaging in prostitution was fit?
I am not prepared to represent the thousands of cases the department has prosecuted over the years and to answer that question. I concede that engaging in prostitution may be relevant and an evidence of unfitness.
I can't see, I mean, I obviously, well, not obviously. It's a pretty big stretch to give a kid to a prostitute, I think. That is someone who's actively engaged in prostitution, I think. Now, I'm sure that the law is something like that mere one fact alone, if it doesn't affect the, you know, the ability to parent, blah, blah, blah. But it's a tough one.
If I may, Your Honor, I would say that that does need to be taken into account the remainder of the factors and the remainder of the facts. And the evidence still shows that this judge, and I cite custody of Tracy, particularly because we're dealing with a judge and not a jury trial, unlike the cases cited by my sister. We're dealing with judges who see frequently, not infrequently, people engaged in prostitution and make determinations about parental unfitness as to how much that's worth. And this court has determined that ultimately it is for the judge, and we trust the judge to determine it. There's nothing on the record to show at all that she was unduly influenced by that one thing. And there's nothing in the record to show that that witness's testimony swayed in any way the ultimate determination.
All right, no, go ahead, Judge.
No, counsel, as you know, we see a lot of these cases, and at least in cases in which we affirm the termination, it's fairly easy to write up the portion of the opinion that says the mother is unfit because. Complete that sentence in this case.
Sure. So particularly in this case, what you have is you have a mother who's been involved for the better part of her life with the department, either as a child or as a parent. Certainly the better part of this child's life. And what you have essentially is a mother we know who has a documented anger management issue. We have a mother with a conceded history of mental illness that has been ineffectively treated, and an anger management issue that's been ineffectively treated. And what we also have is a mother who has demonstrated, and the court found in conclusion 12, that she does not understand the issues raised by the child's behavior. The court went out of its way to find that the child's behaviors are remarkably similar to the mother's own behaviors. And the fact that she hasn't controlled her own behaviors is evidence that she's ill-equipped to deal with the child's behaviors.
Which behaviors are these?
That would be the angry outbursts. In the mother, we see that with a history of potential assaults on her grandmother. We see that in...
Can we stop on the assault on the grandmother?
Yes.
I'm having a hard time understanding where the judge in the record relied on that. It appears to be the investigator's report, which relies on the DCF investigator's report, which relies on out-of-court statements by the putative combatants. Why isn't that triple-level hearsay?
Well, it may be triple-level hearsay, but as this court determined, and as the SJC just confirmed in adoption of Luke, it's admissible, so long as those declarants are all identified and available for cross-examination. So I can go back and look and see whether it's double or triple level hearsay.
The problem I'm having is a lot like what Judge Milkey said. I agree, she's angry and has an anger management issue, it appears. I can't say I agree, but the judge, I think that's a supported finding. I'm having a hard time seeing how that has affected her parenting. Because when she was removed, when he was removed from her the final time, it was because she appeared out of control and out of it on marijuana, something. And there's no indication, I'm not saying that's not a repeated issue, but the record doesn't show that. And then she's really angry at DCF a lot, and that's not good, but the question isn't whether she can have care and custody of DCF, it's whether she can have care and custody of this child. And I gather everyone agrees that at least until the first removal, she was doing okay.
Well, are we referring to the first removal of this care and protection or the prior one? Remember, this is the second care and protection. So her history of parenting doesn't begin and end with this first removal, as you're saying. There is a prior history where she was not necessarily doing well. She did well enough to be reunited with her child, but there is a history of neglect that led to an initial care and protection as well. But I will also directly answer your question about the nexus, if you would like, Judge Rubin. And I would point out specifically that her anger management issues have a direct result in resulting in her housing instability, which was a large issue for this court. Her anger management issues, to go back to the issue of the assault on the grandmother, resulted in her being kicked out of her grandmother's house and having a restraining order taken out against her, which led to the succession of 15 transient homes. So her anger management directly influenced her housing. Her anger management at the department shows, and I've cited testimony from the social worker in here, her inability to focus on her current issues as a parent because she constantly hearkened back to her trauma as a child. Now,
and
that
her current issues as a parent are
her inability to find a stable housing, her inability to access services to adequately treat her history of trauma and her current anger management, which may be related. These are current issues. And the anger management is also relevant, as the court found, because the child manifests anger management also, and the mother's ill-equipped to deal with the issue on her own, let alone with regard to the child.
Now, we don't usually take kids away from angry parents, and kids do grow up angry, and it's terrible, and these are multi-generational problems. But let me ask you about how she did, how the child did. I want to get to the best interest piece of this too, and your time's expired, but I have a feeling we're going to keep you a little longer. Can you talk about the best interests of the child? We're talking about a 5-year-old child who's disruptive at home, who is about to be made or will be made a legal orphan with no, I mean, maybe it's changed, maybe things are great now, and you can tell me, or counsel for the child can, that you found a pre-adoptive resource and so on, but it seems like it's not the most, that this is not ideal, an ideal situation for seeking an adoptive resource, and yet, you know, and the child has some relationship with his mother. I'm trying to figure out whether the kid got worse in foster care, because that's how it looks to me. And it's true, obviously, that late visits and maybe even visits with the mother were disruptive in some way, but they're so infrequent. I don't see how they can be the sole cause for someone deteriorating in foster care. And maybe you can just talk about that a little bit.
Sure. Well, I want to be clear that I don't believe that the trial judge, the finder of fact, found that the child's behavior had worsened in foster care. There's no question that he exhibited problematic behavior when he was in foster care at the outset. But just to quickly look at a few of the court's findings on that issue, look to finding 294 to 295, the court finds that the child's behavior improved in school. You will look to finding 289. You will find that the court found that the child no longer required in-home individual therapy and counseling because his behavior had improved. If you look at finding 309, the move into the new foster home, you will find that the trial court found that his behaviors largely subsided, the problematic behaviors. That shows a trajectory and a pattern of general improvement.
Except for the part where he's kicked out of his foster home for violence.
Well, respectfully, Your Honor, it is speculation to determine why he left his foster home.
I thought it said that he had pushed 2 children off the couch in some dangerous way. Or it doesn't link that to his...
If I may answer you, Your Honor?
Please, of course.
So, yes, there's a finding that he did push a child off the couch. I don't deny that. That was sometime earlier than when he was asked to leave the foster home. There is a finding he was asked to leave the foster home because the foster parent, the first one, said they were not in a position to care for him on a long-term basis, but they would nonetheless keep him until a permanent family was found. There is no causal relationship between those findings. There is no indication of the length of time between those findings. I would submit that there are many reasons that this foster parent might have asked this child to leave the home. It could have been their own personal health or age issues.
We know that? How can you know what's in this child's best interests without any idea of why a foster family decided, who had said, we'll keep him until he has permanence, just to change their mind? I mean, of course, it could be any of a number of reasons, of course.
Well, you're right. And here, sitting here on a Zoom argument years after the fact, without evidence in front of us, we don't know. But the trial judge heard the trial. The finder of fact was satisfied that that was appropriate. It's her job to make that determination. It is, other than that, we are merely speculating as to why the child was asked to leave. And it is just as dangerous to speculate that it was forced.
Oh, yes, I agree. It's a question of burden, though, unfortunately, as so many of these things are. Can I ask you, the child is no longer in that foster placement?
Which foster placement?
The second, the one that the child was in.
I do not know.
And has a pre-adoptive resource been found?
I do not know.
Okay.
But I would ask if you would indulge me for another minute. And I would say, since we're talking about the question of legal orphan that you raised, Your Honor, the issue here is not whether this child's a legal orphan, as inaccurate and problematic as that term may be, because the child's not a legal orphan, by the way, after a termination of parental rights. The child's mother is still the mother. And the child may still have a relationship with that mother if it's in the child's best interest. That is the very reason, if I may, why we have post-adoption visitation. After all, in all of these cases where post-adoption visitation orders are made, the mother is terminated on, but the visits continue. So
has there been any visitation since the order?
I can answer no questions with regard to anything that's happened after the record, unfortunately.
Okay, we'll ask child's counsel.
But what I would say is that ultimately, you can look at the plan, and there may be a problem with the plan, though I would submit that the trial court was satisfied, and I rest on my brief for the reasons why there was adequate support for the plan to be approved. Nevertheless, when a parent is deemed unfit, and when there is a pattern of unfitness, and if it is sufficient, such that the trial court didn't err in finding that there was not a reasonable likelihood that the parent would become fit in the near future, then the decree doesn't get vacated. This court said that recently in Varick. Maybe there are further hearings on the plan, but the decree does not get vacated because it is not in the child's best interest to be returned to an unfit parent and one who will not be fit anytime in the near future. That is black letter law now. The only question is where the child goes. If it's not the home, then we don't vacate the decree. And I would submit that that's what this court determined, and there was adequate evidence to support it.
All right, thank you very much, and thank you for your willingness to continue beyond your time. We will hear now from Mr. McCarthy.
Good morning, Justices Ruby, Milkey, and Massing, and good morning to my fellow counsel, Robert McCarthy for the child. And Justice Rubin, to answer your question about the child in a pre-adoptive resource, there has been a pre-adoptive resource identified. That is according to the social worker who I spoke with, who I communicated with recently. There has not been any visitation since the trial. And the child is anxious for permanence in his life. This child has gone through 2 care and protection cases. One started when he was 7 months old. The second one started when he was 2.5 years old. And he's been in state custody for most of his life. And he's looking for permanence. Now the child is almost 7 years old. So he went from 7 months old to 7 years old. And he's really looking for permanence. Childhood is fleeting, and he's looking for permanence as soon as possible. And as far as I know, Justice Rubin, the pre-adoptive resource and the social worker and the trial counsel and the former foster parent is watching this video, and they're interested in his life, and he does have people that are interested in him and are looking out for his best interest. The child isn't seeking to impose a moral judgment on the mother, and he's not denying that his mother loves him. He's just looking for permanence. Mother struggled with many serious difficulties in her life, and the judge issued extensive findings of fact, and they were based on 7 days of trial, and there was at least 45 exhibits admitted into evidence. So
well, could we address one of those findings of fact? The judge said that there was no evidence of a significant bond between the mother and child. Yet you can look at the DCF reports themselves which talk about a bond between the mother and child. And you've heard your sister argue that in term for good and for bad, the observations about the trauma that the mother's lateness may have caused, if anything, probably shows there was a bond rather than not. So how do you address that particular finding of fact?
Oh, yes, Justice Milky, that's not necessarily the way the child would interpret it. The child looked forward to visits, but I mean, a child might look forward to visits, might look forward to going out with his uncle on a walk and get disappointed if the uncle doesn't show up for the date that he was supposed to. Regarding visits, the difficulty with visits in this case is mother struggled with attending visits for the entire length of the case. Between May 2017 and February 2018, she was offered 35 visits and only attended 7, and she was late for 3 visits. In 2017, she missed a 2-month straight period of time where she didn't visit with the child. And then in 2018, when the trial started in 2018, she missed 50% of the visits that she was offered. That doesn't show a mother that's interested in trying to establish a bond with her child. Mother's complaint really is about post-trial visits, the adoption plan, a counselor, and reasonable effort. She doesn't really complain. She said it in oral argument, but in a brief, she doesn't really complain wholeheartedly anyway about her fitness. From the child's perspective, the focus on this appeal is mother's fitness and her ability to take care of him. And the child would tell this court that she cannot take advantage, she cannot take care of the child. She was given extra time by the trial judge. The case was filed, I think, in 2016. The trial started in 2018, and she was given 2 years to follow her service plan to become a better parent, and she didn't do that. At the time of the trial, as of August 2018, during the midst of the trial, she was not in compliance with her action plan tests. So the child has an absolute liberty right to be free from abuse and neglect, and his interest in being free from abuse and neglect is absolute. And he believes that sending him back to his mother would be sending him back to a mother that couldn't take care of him.
Have you met with your client?
I have, Your Honor. Judge.
How recently?
It hasn't been recently, Judge. What I do in these cases, I've been doing them for a long time. I've been practicing law for over 35 years, and I've been doing this for 26 years. I meet with the client, and I think most of the care and protection attorneys do. And then my system is to keep in contact with the social worker, the trial counsel, and the pre-adoptive parents of the foster care resource monthly to determine how the child is doing. And that's what we do.
Counsel,
oh no, go ahead, Judge.
I'd be interested in a very short summary of what process you use to determine the best interest of the child. I mean, do you view yourself as a quasi-guardian ad litem, or how does that work?
I view the child's counsel is tasked with articulating the views of the child, and then if the child can't articulate those views, to substitute judgment for the child. The child sees this. The child sees this as far as best interests are concerned. A mother struggling with mental health issues, that he's been in state care for most of his life. The mother can't get her act together regarding housing. She complains about transportation. She hasn't visited with the child when she had the opportunity to, in a regular fashion or in a fashion that might create a bond. and she struggles with education. She was given $800 a month. She was supposed to get $800 a month to use to care for the child, and she couldn't follow the simple directions the TCF gave her about providing proof that she was enrolled in a degree program or had a full-time job, which she couldn't seem to hold down, the full-time job.
Can I ask, is the child in the same foster placement that he was in at the time of trial?
That's not my understanding, Justice Rubin.
Do you have any idea how many foster placements he's been in since trial?
I believe it's just been one, but I can't stake my life on that.
And is that the pre-adoptive resource, or that's yet another?
That is the person before the pre-adoptive resource. So again, we're asking this court to affirm the judgment of the trial court, find mother unfit, keep the judgment terminating parental rights, and affirm the decision of the trial court. And we would thank you. And if there are no questions, we rest on our brief.
I see no more questions. Thank you very much, counsel, all of you. This is, as these all are, a difficult and sad, unfortunate circumstance and case. And we, as it must be clear, have great concern about the children in these cases. So with that, the case is submitted, and that concludes our session for this morning. We therefore stand in